Imagine going to prison for 20 months because, because you retweeted a cartoon to an audience of less than 100 followers.
Yeah, it sounds completely absurd, but that's exactly what happened.
Right. And today's deep dive is about exactly that. We are unpacking this truly fascinating intersection of law, network science, and artificial intelligence.
It's a really wild mix of topics.
It really is.
Yeah.
So we have a unique stack of sources today detailing a specific cyber speech legal case from China. But what makes this stack extraordinary is that we are looking at this case alongside highly technical legal analyses generated by 6 different AI models.
Yeah, 6 of the major ones.
Right, we're talking ChatGPT, Copilot, DeepSeek, Gemini, Qwen, and Grok.
It is a remarkable set of documents, really. We get to watch how different artificial intelligence architectures process, analyze, and, ultimately deconstruct human legal reasoning.
Exactly. And just as a quick ground rule for you listening, before we jump in, we are dealing with some highly charged political source material today regarding the Chinese judicial system and ideological concepts.
Right, and it's important to be clear on our stance here.
Yes, very important. We aren't taking any political sides here, left or right. Neither of us are endorsing the specific viewpoints contained in these documents. We are purely acting as your guides, basically, to the legal arguments, the scientific principles, and the AI analyses exactly as they appear in the text.
Right. Our focus is strictly on the structural logic of the arguments. We are looking at how a human defended himself using physics and philosophy, and how artificial intelligence evaluated the actual math of a criminal conviction.
So let's get into the human at the center of this. The sources introduce us to Dr. Chen Jingyuan.
Yes, Dr. Chen.
And he is a PhD scholar specializing in nonlinear complex systems.
Which is going to be incredibly relevant later on.
Oh, absolutely. So he had actually moved back to rural Yunnan to live a quiet life, occasionally helping his parents and focusing on his independent academic research. But according to a document he wrote, which he titled his Blood Letter from Prison, police violently raided his home.
Yeah, and his arrest was entirely based on his activity on Twitter, which he was accessing using a VPN.
The details of the so-called crime are just staggering. We are talking about sporadic retweets here. Under 100 total, spread out over several years.
Right, not exactly a viral influencer.
Not at all. His audience was less than 100 followers, mostly what he described as zombie fans or, bot accounts.
Barely anyone was actually seeing this.
Exactly. And the content he retweeted included posts from the U.S. Embassy, a cartoon of a Hong Kong umbrella girl, and some various historical critiques.
And for that specific, really tiny digital footprint, he was charged with a crime known as picking quarrels and provoking trouble.
Which is just a crazy name for a charge.
It is. And the result of that charge was a 20-month prison sentence.
I want to pause on that charge for a second. Picking quarrels and provoking trouble. I'm trying to wrap my head around how, hitting a retweet button on a cartoon drawing fits into that legal framework.
Yeah, it's quite a stretch.
Is this essentially a pocket crime? Something like a legal junk drawer where authorities just toss any behavior they don't like when it doesn't fit neatly into a defined statute?
Actually, yes. The AI models, particularly Copilot and Gemini, they flagged that exact issue.
Oh, they did?
Yeah, they point out that this specific charge is historically used in an expansive catch-all manner. In this instance, the text suggests the authorities basically reached into that legal junk drawer because there was a distinct lack of evidence for more specific crimes.
Like what kind of crimes?
Well, if you cannot definitively prove defamation or inciting subversion, a vague charge like provoking trouble becomes a very convenient fallback to just penalize speech.
Okay, that makes sense. But the fundamental requirement of any crime is an illegal action. You have to actually do something against the law.
Right, the action itself.
And in Dr. Chen's case, the action was allegedly spreading false information or rumors. So here's my question. How do you legally prove a retweet is a lie?
Well, you have to look at the nature of the information itself. And this is where Dr. Chen's defense is just incredibly systematic.
Because he's a complex systems guy.
Exactly. He didn't just stand up and say, I didn't do it. He categorized his retweets into 4 distinct types.
Okay, break those down for me.
Category 1 is art and cartoons, which covers that umbrella girl drawing. Category 2 is subjective emotional expressions.
Okay, so just personal feelings.
Right. Category 3 is rational theories or viewpoints, and then Category 4 is objective historical descriptions.
Okay, I see where he's going with this. And the AI models, especially DeepSeek, Qwen, and Copilot, the universally praised this classification system.
They did, and for a very specific reason, because the first three categories are fundamentally unfalsifiable.
Right.
That is the mechanical problem for the prosecution here. You cannot prove a cartoon is true or false in a laboratory or a courtroom.
No, of course not.
You can't objectively measure the factual accuracy of someone's personal emotional expression or put a theoretical academic viewpoint on a scale and weigh its truth.
It makes complete sense. I mean, if I retweet the ancient poet Li Bai saying his hair is 3,000 feet long, no judge can look at that and declare it a malicious rumor about human biology.
Right, exactly.
It is art.
Yeah.
It is expression. So how did the judicial authorities handle that nuance?
Well, according to the text, they employed what the AI models call a packaged approach.
A packaged approach.
Yeah, they just bypassed the categorization entirely. They took this incredibly diverse collection of art, emotion, and theory, bundled it all together, and uniformly labeled the entire package as a rumor.
Wow. Which Copilot noted is a massive violation of a core legal concept.
Yes, the principle of nullum crimen sine lege.
Which means no crime without law.
Exactly. The basic idea is that you cannot treat non-factual, unfalsifiable statements as if they were falsifiable facts, just to fit them into a criminal statute about spreading false information.
Right. You are essentially rewriting the rules of reality to make the charge stick.
Which the AIs caught instantly.
Let me push back a bit on the fourth category, though.
Okay, go ahead.
Objective historical descriptions. Let's assume he retweets a claim about a historical event. Doesn't a citizen have a basic duty to fact-check an objective claim before they broadcast it to the public?
That's a fair question, and the LLMs, specifically DeepSeek and Quen, addressed this head-on.
What did they say?
They noted that imposing a universal legal duty on everyday citizens to act as expert fact-checkers for every single piece of information they encounter online is just fundamentally unrealistic.
Yeah, nobody has time for that.
Right. But more importantly, from a structural legal perspective, the burden of proof in criminal law lies entirely with the state.
Ah, okay. So it is not Dr. Chen's job to prove his retweet was historically accurate.
Exactly.
It is the prosecution's job to prove, beyond a reasonable doubt, that it was objectively false.
And the AI analysis shows the prosecution totally failed to clear that hurdle. They didn't provide authoritative debunks. They didn't bring in factual evidence proving the historical posts were lies.
They just packaged it all up.
Yeah, they just slapped the rumor label on the whole package and moved on.
So they failed to prove the action is a lie. But even if we pretend they succeeded, they still have a massive psychological hurdle to clear.
The intent.
Right. To be guilty of a crime like this, you need malicious intent. The legal term is mens rea, the guilty mind. So, did Dr. Chen actually know he was spreading harm?
The court's primary argument for his state of mind is one of the most heavily scrutinized parts of this entire case.
What was their argument?
The judge basically argued that because Dr. Chen has a PhD and a high level of education, he, quote, should be able to distinguish right from wrong.
You're kidding.
No. And from that assumption, they concluded he knowingly spread rumors and possessed malicious intent.
I want to make sure I'm hearing that correctly. That's like saying a master mechanic is automatically guilty of stealing a car simply because they know how an ignition system works.
That is a perfect analogy.
You are using someone's education level to completely bypass the need to prove they actually intended to commit a crime.
Right, and the specific legal term for that is objective imputation. And Gemini and Grok tore this logic apart.
Break down objective imputation for me, just so we're clear.
Sure. In criminal law, you usually have to look inside a specific person's head at the specific moment a crime occurs to prove they had a guilty mind.
Which is hard to do.
It's very hard. So objective imputation replaces that specific, difficult investigation with a generic external stereotype.
Oh, wow.
Instead of proving this particular scholar intended to cause harm, the court imputes or assigns guilt by saying, someone with this status ought to have known better.
That's incredibly dangerous.
It is. It violates the presumption of innocence by turning a PhD into a liability that literally substitutes for actual evidence.
So how does a scholar who specializes in complex systems defend himself against that kind of logic?
Well, he brings in philosophy and mathematics. Dr. Chen referenced Plato's cave and Gödel's incompleteness theorem to argue that human rationality is fundamentally limited.
Okay, I am familiar with Plato's cave. That is the allegory where people are chained facing a blank wall watching shadows cast by objects behind them.
Right.
And they mistake those two-dimensional shadows for absolute reality.
Exactly. He is arguing that social media feeds are just the shadows on the wall. No one is seeing the absolute full truth online. But then he also brings in Gödel's incompleteness theorem.
Whoa, okay, stop right there. I've heard the name Gödel, but what does a mathematical theorem have to do with criminal intent on Twitter? Explain that one to me.
So Kurt Gödel was a mathematician who proved that any complex logical system will always contain truths that cannot be proven within the rules of that system itself.
Okay, I'm trying to visualize that.
Okay. Think of it like a dictionary trying to define every single word using only the words already inside it. Eventually, you run into secular definitions or concepts you just can't prove using the limited tools in the book.
So uncertainty is literally baked into complex systems.
Yes. And Dr. Chen argued that his extensive academic training doesn't give him magical access to the absolute truth. It actually makes him a skeptic.
Oh, that's brilliant.
Right. He collects diverse data and viewpoints for research, but because he understands Gödel's theorem, he knows that his own understanding of reality is inherently limited and incomplete.
I love how he flips the script there. The court says, you are a scholar, therefore you know exactly what is true and false.
Yep.
And his defense is essentially, I am a scholar, therefore I know mathematically that I don't know everything.
Yeah.
It is just a beautiful contradiction of their logic.
It really is.
I know he also brought up Schrodinger's cat in his letters, right?
He did. He used Schrodinger's cat to describe the absurdity of the judge's reasoning.
So for anyone who doesn't know, what is that?
The famous thought experiment involves a cat in a closed box that is simultaneously alive and dead until you open the box to observe it. It is a state of probability.
Right.
And Dr. Chen pointed out that the court was looking at a closed box, basically his internal subjective thoughts and the inherent ambiguity of network information.
But they never opened the box.
Exactly. Instead of opening the box by providing actual evidence, the judge just forced a definitive binary legal certainty onto it to secure a conviction.
They observed a probability and wrote down a certainty without ever taking a measurement. That is a massive logical leap.
It is a huge leap.
Okay, so let's look at the third and final pillar. We have deeply flawed logic on the action and highly questionable objective imputation on the intent. But the law requires a result.
The actual harm.
Right. To be guilty of picking quarrels and provoking trouble, did his retweets actually cause the severe public disorder required by the statute?
And this is where the deep dive gets incredibly fascinating. This is where the physics PhD fights back using hard science, specifically complex systems theory.
How does physics disprove a legal charge of public disorder?
Well, Dr. Chen utilized something called the Cia-P theorem in avalanche dynamics. Let's start with the network structure.
Okay.
He argued that a social network is a massive, highly resilient distributed system. Within that massive structure, he is merely an edge node.
Because he's on the outer fringes with under 100 followers.
Right.
So his sporadic retweets are just a drop in the ocean.
He describes it as background noise, and this connects to avalanche dynamics, which physicists often explain using a sandpile model.
A sandpile model?
Yeah, imagine a table where grains of sand are dropping one by one. Eventually, it forms a pile.
Sure.
If the pile gets steep enough, it reaches a critical state where one single grain of sand can cause a massive avalanche.
And the avalanche is this severe public disorder.
Yes, exactly. But Dr. Chen argues that his tiny actions as an edge node physically lack the kinetic energy to cause a macro-level system avalanche unless the system was already in a highly critical, unstable state. And the prosecution never proved the system was about to collapse, nor did they prove his specific grain of sand caused any slide.
Let me play devil's advocate for a second, though, drawing on the text. We have all seen social media go viral.
Sure.
We have seen a single post spark an offline protest. What about the butterfly effect?
Yeah.
You know, the idea that a tiny flap of a wing in one part of the world can theoretically cause a tornado somewhere else.
Right.
If we're talking about complex systems, isn't that a valid legal fear?
It is a very common fear, and the text shows Chen's counter to that exact thought process. The butterfly effect is a theoretical mathematical model of chaos.
Okay.
But a criminal conviction cannot be based on a theoretical math model. It requires actual empirical evidence that the tornado happened and that your wing flap caused it.
So the prosecution didn't prove a tornado happened. They just pointed at the butterfly and said, lock him up because a tornado could happen.
Exactly. And we know this because of the empirical reality of the case. After his release, Dr. Chen actually went back online.
Oh, he checked his account.
Yes. He observed that his so-called criminal retweets are still up on the platform right now. And what is the result? Zero engagement, zero forwards, zero social reaction.
It is absolute silence.
Total silence. And the LLMs, specifically ChatGPT and Copilot, they zeroed in on this.
What do they make of it?
They point out that this is the ultimate empirical disproof of the prosecution's case. The court provided zero data, no retweet metrics, no public opinion reports, and absolutely no evidence of any offline incidents.
Nothing at all.
By skipping the data entirely, the court effectively hollowed out the objective harm requirement of the law.
So let's bring all these threads together. We have looked at the action, the intent, and the harm. What stands out most when we look at the AI analysis of this human struggle?
Honestly, what is most striking in the source material is the stunning convergence of the 6 different AI models.
Because they're all built differently, right?
Exactly. Remember, these models have different underlying architectures, different training data, and different safety rails. Yet ChatGPT, Copilot, DeepSeek, Gemini, Qwen, and Grok all arrived at the exact same conclusion.
Which was?
They universally stated that the prosecution failed to meet the evidentiary standards for all 3 pillars of the crime.
The text calls it a textbook example of conclusion-driven judging, doesn't it?
It does. It highlights a complete absence of evidence. The court basically started with the conclusion they wanted, that this scholar needed to be punished, and worked backward, ignoring the actual mechanical requirements of the law.
It's just wild. And if we step back from the specific details of this one case in Yunnan province, there's a massive takeaway here for you, the listener.
Absolutely.
This deep dive is fundamentally a masterclass in critical thinking and structural defense.
It really is. It shows how you can dismantle a seemingly overwhelming argument that is heavily stacked against you.
You do not just flail and attack the final conclusion.
Right. You calmly break the argument down into its structural components. You test the definition of the action, you test the logic of the intent, and you test the empirical data of the harm.
Furthermore, it demonstrates how applying interdisciplinary knowledge can be a genuine superpower.
Dr. Chen didn't limit himself to legal theory. He used physics, network science, and pure philosophy to disprove legal causality.
And when you step outside the boundaries of a single specialized discipline, you can spot the structural flaws in an argument that specialists might entirely miss.
The court tried to present a very simple, linear story. A bad man tweeted bad things and caused bad trouble.
Right. But when the AI models and Dr. Chen shone the light of complex mathematics and network theory onto that story, the entire structure dissolved.
There was no severe public disorder. Just a scholar making quiet observations on the extreme edge of a massive network.
Which forces us to ask a really profound question about the intersection of technology, bias, and the law.
Yeah, it does.
And that leaves us with a final thought for you to ponder. If these AI models, which, at their core are fundamentally just rule-based logic engines, if they can so cleanly, systematically, and universally dismantle the flawed logic of a human legal judgment, what does that mean for the future of our justice systems?
It's a huge question.
Could AI eventually serve as an impartial auditor? Imagine a tool sitting quietly in the background of our courts, designed specifically to catch human biases, logical leaps, and conclusion-driven judging before a real person loses 20 months of their life.
It's definitely something to think about.
Something to think about next time you hit retweet.